Nsem-Pii TV nie.
Breaking news live from Accra High Court. Yes, the Criminal Division of the Accra High Court. Justice Efia Serwaa Asaributwe edini ruling Ababetuja on 4 applications. The first accused, Kaisel Atoforsen. The third accused, Richard Jakpa, ede ebetunenim eda eye wukwada. Now, the ruling comes as a result of, say, Justice Efia Serwaa Asaributwe Nensa Enyan can rate bia from the Supreme Court. No, say on stay proceedings. Say the can report man say Jakpa. And the lawyers at the Aquaco PM Supreme Court no. So the Court of Appeal judge, the sitting trial judge no, or the ruling and then the judgment about Betuja. Now can Nsem-Pii at the chair Richard Jakpa can be chair at Atoforsen. Obi also she had words of advice for the learned Honorable Minister for Justice, that is the Attorney General Godfred Yeboah Dame. Now this is the information and Nsem-Pii TV here picky from the Criminal Division of the Accra High Court. Yes, I say application for mistrial filed by Dr. Kaisel Atoforsen and Richard Jakpa has been dismissed by the court. Now actually say at the T3 pound did kind in their application at the Wukwada no say Ekabeya nka Justice Efia Serwaa Asaributwe won declare say ensan ba bia yaka duru nyina yaka no kwa yaka gu ye sign eba be hyase foforo ye be share asem na say right from the start with a new judge or better case ni so with a new lawyer in place for the state, that is Attorney General odan be twene ho na foforo aba be gina ne name isan say o feel say he has made some inputs into the ongoing trial now. And my trial no enye pepepe se de omusi pen no eno na Justice Efia Serwaa Asaributwe say nsem no mo ka no omu ni nyina so bia their application does not have any merit until we dismiss the application for mistrial. Now sanso dismiss Kaisel Atoforsen the stay of proceedings or injunction our file yensenka yentwentwen so kopem say omo affidavits ahodo a omo de ka omo case no court no ebehwehwem na se nukrobi wo ma wajitum ede abom and so it has been dismissed by Justice Efia Serwaa Asaributwe. Amfi Court of Appeal judge Justice Efia Asaributwe esan so ekachire the learned Attorney General Godfred Yeboah Dame, and these are her words. I say to uphold public confidence in trial, do not be directly involved. Now just said the beya timemufuo omo wan chen omo follow court proceedings omo follow court case no said the esi akwa kosi no enye obitrimu na say ensem wan DC for kan ye no kre Attorney General pese o dada Richard Jakpa mane kasem to implicate Atoforsen enye sa ne na benti no next time and now whenever there is a trial going on, the Attorney General should not engage any accused person and found home say nipa na nkasa na betutu ne nine ababe PM e the office of the Attorney General and found home say nipa no eba kodan Supreme Court judge bi ama Supreme Court judge na afre no say omra fie ni nkomo so ko PM ni fie na sa nkomo na mba be di no efa an ongoing trial ho a Justice Efia Serwaa Asaributwe say the Attorney General or any state prosecutor at all should not engage any accused person. Words of advice are Justice Efia Serwaa Asaributwe edituja the Criminal Division of the Accra High Court Brian ne otenasia or di ni ruling ebebe tuja na ebeka ya on this same issue ya report to the amount say Richard Jakpa and the lawyers are file application Supreme Court. The Supreme Court also emremu na o me determine to say ya Justice Efia Serwaa Asaributwe ed ruling abey yebehwe say Supreme Court ebe uphold the decision of the High Court, and now say Supreme Court ebe determine say some Richard Jakpa and lawyers by ede by no enough merit am one question the ruling of the High Court one that one is also pending eba be cancer Nsem-Pii for mama maswati na say CID breaking news a free Accra High Court eba say application for mistrial filed by Kaisel Atoforsen Ena Richard Jakpa de file here, see and drop charges ni nyina against no. It's answer on there. He is an innocent man. Onye boni bia na emum attorney general na person dada no man implicate ya to force no. Sa applications ni nyina e ma me justice efia Serwaa Saributwe wa boni nyina e dia to agu. On this issue, astute professor of law Kwame Jan akasa dia fa ho. Momi ntie nsem a odi atudwa.
Is the case of Abina Pokia Aka versus Agricultural Development Bank, which is a Supreme judgment. And then there is Raphael Kubaji. It's a famous case versus Makiyabu Asari and two others. So these are Supreme Court judgments which have expounded the law, and the results from these two judgments is that when your communication is recorded secretly without your consent, it offends our laws. And there are serious restrictions as to the admissibility of such evidence, even during trials, because of the way these kinds of evidence have been obtained.
Right.
So, recording secretly the conversations with or of others without their consent, it is not just in this country. If you go to the United States, almost all the 50 states have laws which criminalize recordings without either the consent of one party or consent of both parties, except under very limited circumstances prescribed by legislation.
Professor Jan, you speak to admissibility of this particular circumstance. Again, I want to find out from you that in as much as that could be argued, are there exceptions or some circumstances within which we find ourselves in under which these recordings might be considered legal or admissible in court?
So, for example, if the police, for some reason, are investigating a crime or suspect that a crime may be committed, they would go to a court of competent jurisdiction and seek leave of the court and obtain same and tap into your communications with leave of a court of competent jurisdiction. In that situation, admissibility should not be a problem. In other situations, our law, if you go back to our evidence decree, the evidence decree, which is now the Evidence Act, because of the Statute Law Revision Commissioners Act, is one of the best pieces of evidence decrees in the world, or evidence legislations in the world, because the drafters, led by a late Court of Appeal justice called Justice Ofori-Boateng, famous judge, they studied the evidence laws of almost every civilized jurisdiction and tried to find out what is the best practice before they created our own system. Now, in American jurisprudence, there's a principle which is known as the fruit of the poisonous tree. It's one of the principles that applies in the law of evidence, which says that where a tree is poisoned, the fruits of the tree are also deemed to be poisoned. In non-legal format, it means that if evidence has been collected in a way as constitutes a violation of law or rights recognized by law, the evidence will not be admitted to establish the guilt of an accused person. But you made a point. There are circumstances under which that evidence may be admitted. And in fact, in the case of Raphael Kubaji versus Michael Yeboah and two others, the Supreme Court set out the parameters of admissibility and made provision for the evidence to be considered on its own merit, depending upon the gravity of the offense that is on the table. So the courts have a way of dealing with it. But the general principle is that where the tree is poisoned, the fruits are also poisoned. That's the general principle. But like all general principles, there are exceptions. There are exceptions.
Right.
But the exceptions don't become the rule. They remain exceptions.
Talking about these exceptions, are you able to elaborate further whether there are legal distinctions between recording a private citizen and recording a public official, as has happened?
Honestly, our laws from the constitutional framework through statute and case law, our laws have not distinguished between how you treat conversation with a public official and how you treat conversation with a private individual. Now, let me sound a caveat here. When it comes to the law on libel and slander, generally, the law on defamation, the courts expect public officers to have thicker skins. In other words, if you're a public officer and I say something defamatory, so to speak, about you, the court would expect that the level of the standard which is required to satisfy proof of defamation when the allegation is about a public figure is different from when it is about a normal citizen. Because the court says that once you have come into the public arena, you must be prepared to take some heat. Because if you come to the market, you are going to be treated like any player on the market. So that's one slight distinction. But when it comes to recording without consent, our laws do not draw a line between when you record a private citizen versus when you record a public official. The standard as the law is now is the same.
Be the first to know Nsem-Pii TV.